3839, People versus Sean Johnson, 23-782-765 of H.
I'll ask you the people.
Andrew Bannis with it on behalf of Sean Johnson. Mr. Johnson, can you hear us?
Yes.
Hello, Mr. Johnson.
Good afternoon.
Your Honor, I need to make sure my client understands that I have been advocating for his release on a GPS tether. He's willing to do anything in terms of 90, etc., testing. He has a lot of concerns about the collateral consequences of being incarcerated. Our pre-docket conference led me to believe that you are not letting him out today. And in fact, you gave me an indication of what his sentencing might look like if we get to that point, which is serious. I am at the point where I am advising Mr. Johnson, I spoke with him today, to set this for a jury trial and a final pretrial. Not that he wants, well, he would prefer to resolve it in a different way that is not available as of today.
Buckle up, guys. Today we're going to witness a tense courtroom showdown. The video kicks off with the host setting the scene, highlighting just how wild this hearing is about to get. As a judge calls the case and the defense attorney checks in, the stage is set for a battle over freedom, responsibility, and consequences. This short intro packs just enough suspense to pull you right in before the real clash begins.
Is there an offer that's been forced by the people, or do you need to put it on the record now?
No, there has not been an offer.
So no offers.
Can't hear.
No, we can't do that.
February 12th, Mr. Johnson, for trial.
Your Honor,
I can't hear anything.
we need a different day because Ms. Noveski and I would be conducting the trial together, and she's not available on that day.
Mr. Johnson, can you hear us now?
Yes. Am I allowed to speak? I would like to speak to you, Your Honor.
I have advised my client that if you allow him to speak, then it should only as it pertains to any bond situation, not about the underlying allegations. And I think he understood that.
Okay. Mr. Johnson.
Oh, good afternoon, Your Honor. While here in jail, I did attend to the Dawn Farms course, and I completed that with a certificate. And I attended AA also here in the jail. And I do admit that previous charges have been because of alcohol.
Here the defense attorney wastes no time pushing for his client's release. He asks the judge for a GPS tether, hoping that some form of monitored freedom might be granted. But the cracks start to show immediately. The judge reminds everyone that this case is serious and the punishment could be harsh. What begins as a routine request quickly turns into the first sign that freedom is slipping further out of reach for the defendant.
I'm very eager to I would like to go home. My mother-in-law did pass away several days ago, and I'm definitely willing to wear an alcohol tether and even drug test or whatever it might be. And if I can please have contact, because Sandy would really like me home, and she hasn't come to any of the court dates, and I extremely miss my daughter. If we could at least maybe drop the DV charge so I can go home and come back for a court date.
Tension rises when the court confirms there's no plea deal on the table. The defense tries to address scheduling, But before it can go further, the defendant himself steps in, asking to speak directly to the judge. It's a risky move that shifts the spotlight, signaling that what comes next won't just be legal arguments. It'll be a personal plea for freedom. The suspense builds as the judge allows him to talk, knowing things could spiral quickly.
Mr. Johnson, that for so many reasons isn't going to work. I understand you're not happy where you are and you don't want to be where you are, but I'm also of the mind that alcohol does not cause violence within the home. That's something else. It can exacerbate it, yes, but it's not the root cause for it. I believe under 6106, which are the rules that I need to look at regarding bond, that you are where you should be right now, and I need to do that to protect our community and protect Sandy.
He wants
You have a violation pending. You also have right after arraignment on a new charges where we added no contact with Sandy, and we talked about the drinking issues shortly thereafter. That was on. Then we're now dealing with this home invasion. First degree, we're dealing with domestic third, destruction of property. I'm not willing to do that. I don't believe that you present to this court having someone who can be safe in the community. So your bond will stay as it is.
I'm definitely safe, Your Honor.
Now the defendant makes his heartfelt plea. He talks about rehab classes, blames alcohol for his actions, and begs for release. He even asks for the domestic violence charge to be dropped, hoping to sway the court with promises of change. But the judge isn't convinced. She sharply rejects the alcohol excuse and fires back that protecting the victim and the community comes first. It's a crushing moment that shows just how little leverage he really has.
With contact.
I understand that. I understand what you're telling me today. What I'm saying is I'm making the decision, not Sandy. Then you are staying in. Your next court date is February 8th.
Why am I being pressured to take it to trial?
Your Honor,
There's no offer against you. You have the opportunity to plead guilty as charged, or you have the opportunity to set it for trial. Those are your two options for today. In regards to the violation of probation, I understand there's a prison recommendation.
There is.
There is a recommendation to send you to prison for following a guilty plea or a guilty disposition on these new charges.
The home invasion is supposed to be a third.
This part is where the hammer comes down. The judge runs through the charges, domestic violence, destruction of property, even home invasion, and makes it clear these are not minor issues. When the defense asks again about bond, the judge refuses outright, declaring that his release would put others at risk. Even as the defendant insists he's safe, the judge stands firm, and the hope of walking out of court today is completely shattered.
Okay. Mr. Johnson, there's nothing else that we have on for today's hearing. If there's another issue that needs to be addressed, your attorney will bring it to the court's attention.
thank you, Your Honor.
Can we have a much sooner court date, please?
That is much sooner than the last trial I think was in May.
Why do I feel like this is being rigged?